hearing. It's the time being 1 o'clock. We are waiting for one member to arrive. But we do need to get started right away. We do have members who are chairing other hearings this afternoon. So as we are waiting, let me just make a few announcements. 2 measures on today's calendar have been withdrawn at the request of the authors. And I noticed one is already actually withdrawn from the agenda. Senator Runner did have a measure that is off calendar. And Senator Leno's measure is also off calendar this afternoon. So the bills we will be hearing are SB 189 by Senator Lowenthal, SB 330 by Senator Yee, SB 438 by Senator Yee, SB 580 by Senator Wright, and SB 650 by Senator Yee. And Senator Lowenthal, we do need another member, but if you want to come forward and get ready, I anticipate he'll be walking in the door any moment. Do you have an objection for starting? We're going to go ahead and get started as a subcommittee. Thank you very much. And we'd also like to welcome a new member to the committee. Senator Lonnie Hancock is joining us, and she's a former member of the Judiciary Committee on the Assembly side, so we're very, very happy to have her here. Welcome, Lonnie. All right, Senator Lowenthal, whenever you're ready, SB 189, Mechanics Liens.
Thank you, Madam Chair and members. First, I'd like to thank the committee staff for all their hard work on the bill. Actually, I'd like to thank a lot of people. This bill has been ongoing this is really the second version. We started on this, I think, in 2008. But I know the California Law Revision Commission has been working on this for 10 years prior to that. And I accept as author's amendments language to delete Title 1.4C, the automatic checkout system of the bill, which has nothing to do with the mechanics lien, to address a drafting error. That's page 14 of the analysis.
Yes, and members, that is reflected in the analysis.
Thank you. SB 189, members, includes all of the non-substantive provisions that were in SB 1691. Remember, that's the one I had introduced in 2008 that had both the substantive and also the non-substantive changes. That bill passed out of both houses and was received at that time in 2008 the governor's standard veto, where he was vetoing all bills. And that was even more complex than this bill. During the interim, my staff and the California of this past year and the California Law Revision Commission, whose recommendations this bill is based upon, held 2 lengthy meetings with all the interested stakeholders, where stakeholders had the opportunity to identify any areas of concern with SB 189 and to discuss solutions. The bill before you today reflects my efforts to address those concerns, which have resulted in either support or neutrality from the participating stakeholders, almost all of them, actually. I will continue to work with the interested stakeholders, and I commit to not presenting the bill to working through the bill on the Assembly floor until June, to give the stakeholders, again, ample time to identify any remaining areas of concern. And I'm confident that SB 189 will ultimately be a consensus bill by the time it reaches the governor's desk. SB 189 reorganizes, restates, and modernizes the existing mechanics lien statute to improve clarity and usability. We've all know over the years that the bill is mechanics lien law is very complicated. People frequently don't understand it. It's very arcane, and frequently it ends up in litigation because of the lack of understanding. What SB 189 does is to try to just restate and modernize the statute. It also has a few substantive changes, which included adding licensed landscape architects to a list of design professionals that may claim a design professional lien for design work done on a project. It's standardizing the statutes of limitation for claims made against payment bonds on a work of improvement. The bill also standardizes the number of days after which a work stoppage on a work of improvement is deemed to constitute completion of the project, and it also increases the fee that must be paid to any public entity to receive a notice of specified event on a public work from the $2 that was first set in 1969 to upgrade that to $10, which really doesn't even cover inflation from the 1969 $2. Finally, it becomes effective on January 1, 2012, which allows all the industry and the homeowners to become familiar with the new reorganization. With me today is Brian Hebert and Steve Cohn with the California Law Revision Commission to answer any questions you may have, and I ask for your aye vote.
Thank you very much, Senator Lowenthal, and may I also add my thanks to all those who've worked on this measure. As anyone knows, in the area of mechanics lien, it can be very complex, and just the size of the bill indicates the amount of work that went into this measure. In particular, I'd like to thank the Law Revision Commission for your outstanding work on this, and all the parties involved, because, of course, there are lots of different issues and concerns over the last year and few months. And I do appreciate the fact that all parties are working together to come up with a very good reorganization and modernization of the mechanics lien law. So let me just thank all those. I do know you have witnesses who may want to add something, so if you'd like to speak, please. And we have a rule of 2 main witnesses, 2 minutes each in this committee. So I know it's kind of hard to talk about a bill like this in 2 minutes, but please, if you would like to
Thank you, Madam Chair and members. I'm Brian Hebert. I'm the staff director at the Law Revision Commission. I have with me today Steve Cohen, who's one of my staff attorneys who did most of the staff work in preparing this proposal. We're mostly here just to help answer any questions the members might have, but I do want to echo 2 points briefly that Senator Lowenthal made. The first is to recognize the magnitude of the task that was involved in your staff and in the minority consultant staff in reviewing this and analyzing this very large and complicated bill, and that's much appreciated. And then secondarily, just to affirm that the Law Revision Commission is committed to working with any stakeholder who has any concern about the language or the effect of this bill, and we'll continue to commit our resources to that process throughout the Assembly if the bill is approved today. Thank you.
Thank you very much. Do we have any questions or comments? Senator Harmon, this is the mechanics lien measure, and we just had a presentation by Senator Lowenthal. I know you've also been very vested in the process to where we are today, so you might want to make a comment.
I just had one comment. In our analysis, there was some indication that the Air Conditioning Trade Association of California may have some opposition due to the lack of definition of certain key phrases in the bill. Has that objection been addressed?
Well, what we have done is I think we've kind of resolved almost all the issues, except there may be 1 or 2 that are left out. We have made a commitment just before, and I mentioned that to the committee before, that we will, until this is a consensus bill, we will work with them in the Assembly. We'll not take this up on the floor of the Assembly until we have a consensus and their opposition is removed. We think we can do that. All the other opposition has either been removed or they have specified exactly what they need and want to work with us on that. And so I think we've done a whole lot of work. We've responded to what you have asked for and getting rid of most of the substantive issues and holding that off and limiting it much more to the non-substantive kinds of changes, which is less so than the bill 2 years ago, which was more complex, and we've removed most of the opposition. I think they're the only ones, one other. And we committed to working with them.
All right, good. Thank you very much.
Before we bring it up.
And Senator Harmon, the committee has also heard from that organization, and they are willing to have the bill move forward and on the commitment that parties are working together to address their concerns. Okay. All right. Any other questions, concerns? All right. Any additional testimony people would like to add their support or opposition for the record?
Terry Thomas on behalf of the California Council of the American Society of Landscape Architects in support of the bill.
Thank you very much.
Hi, John Benton on behalf of CalPass, the specialty contractors. We initially were in a opposed position back in December. We've downgraded to oppose unless amended. We're working with Senator Lowenthal and the Law Revision Commission, and we look forward to the process continuing.
Thank you very much.
Andrew Martinez, California State University. We're in support of this bill.
Thank you very much. Any others in support? Any opposition? All right. And Senator Harmon, I know you'll be interested in hearing that if it's necessary to bring this bill back, we will be glad to do that, to keep the parties working together. Okay. Thank you very much. All right. All right. We have a motion on the bill amended with the technical amendment. Any ending comments?
I urge your aye vote.
Okay. And let's just
commit to working with you, the committee, Senator Harmon, and also any of the opposition to make sure that this is a consensus bill.
And thanks very much. Let's just pause for a moment and establish the quorum so we can vote.
Corbett?
Here.
Corbett here. Harmon?
Here.
Harmon here. Hancock?
Here.
Hancock here. Leno? Walters?
All right, we have a quorum. We have a call for a vote, a motion. So let's call the roll on the vote.
The motion is due pass as amended to Senate Appropriations Committee. Corbett?
Aye.
Corbett, aye. Harmon? Aye. Harmon, aye. Hancock? Hancock, aye. Leno? Walters?
All right, thank you very much. It's on call, but it has 3 votes, and that's enough to get out of committee.
Thank you.
Thank you very much. All right, Senator Wright. Senator Wright is here on SB 580, dealing with child support and health insurance.
Okay. Thank you, Madam Chair. Members, I too want to thank the staff and the committee chair for their work making this hopefully a fairly simple bill. 580 is kind of dealing with the federal issue relative to Deficit Reduction Act. It brings California into conformity. I'm not aware of any opposition. Sponsored by the Department of Child Support Services. I have witnesses here with me as needed, and I'll defer to them as necessary.
Thank you very much, Senator Wright. Not Senator Mike. Senator. And thank you also to the Department of Child Support Services. I just wanted to let the committee members know that the mock-up is being made available to you. These represent authors' amendments, which represent the information received by Division of Child Support Services. The reason it's in a mock-up is because we received these this week, but these are supported by the division and sponsored by the division. Are there any questions on those? Okay, everybody's okay? All right, your witnesses in support, please.
I'd like to make just a brief statement. Good afternoon, Madam Chair and members. I'm Sherry Evans with the Department of Child Support Services. Thanks for the opportunity to present this legislation, and I'd like to say that we want to thank your staff for working with us and having patience and dealing with us and getting these amendments to you. It took you could call it a village to get these done. We had a bunch of stakeholders involved, and we think we've come up with the solution in the definitions that the feds require of us.
Thank you.
Madam Chair and committee members, Bill Otterbeck, Deputy Director for Department of Child Support Services. I'm here to answer any technical questions you might have. I do want to reaffirm that this is a federal compliance issue, and it's critical for us to meet our state plan requirements to have these provisions enacted into state law.
Great. Thank you very much. Members, any questions? All right. Okay, I think we've had an opportunity to take a look at them, and we appreciate the guidance and, of course, being able to comply with the federal rules so that we can have this important resource available. A motion's in order. I'm sorry, Senator Wright, would you like to close?
Ask for an aye vote and say the last thing we want to do is get penalized and lose money when we're in such a tight budget situation. So I'd ask for an aye vote.
Thank you very much. It's moved by Senator Harmon as amended. Please call the roll on the vote.
The motion is due pass as amended to Senate Appropriations Committee. Corbett?
Aye.
Corbett, aye. Harmon? Aye. Harmon, aye. Hancock? Aye. Hancock, aye. Leno? Walters? Aye. Walters, aye.
Thank you very much.
Thank you.
Thank you.
4-0 votes. It has enough votes to pass. It's on call, but it will pass out of committee.
Thank you very much.
Thank you very much. All right, Senator Yee, please come forward. Senator Yee has 3 measures on file. We will start with them in numerical order, if that's okay with you, Senator Yee.
That's absolutely fine, Madam Chair.
Okay. The first item is SB 330, item number 2, public records with regard to state agencies and auxiliary organizations. This is a measure that has been before this committee before and passed, and Senator Yee is back with an amended version to address concerns in the veto message.
Absolutely right, and so I won't go over the main body of the particular measure, but just simply say that we've addressed the governor's veto message by expanding the exemption of the Open Records Act to donors and volunteers who wish to remain anonymous so long as they have not received anything more than $500 in exchange for their donation or service, and that should hopefully take care of it.
Okay. Witnesses in support, 2 main witnesses, 2 minutes each, please.
Ruben Santos, Executive Board Member with ASME. I'm also a custodian that works on campus, and we just this bill just brings accountability, transparency to the public university system, and ASME 3299 highly supports this act, and we need this. We need to learn that we can trust the legislators to do the right thing and pass this bill to bring accountability to the UC. Thank you.
Yeah, Jim.
Thank you very much.
Madam Chair, members of the committee, Jimmy, we're California Newspaper Publishers Association. We're one of the co-sponsors of the legislation. As you correctly pointed out, this bill has been before the committee before and unanimously passed out once we had the amendment that addressed Senator Walter's concerns. Just a quick point on the changes between this bill and last year's bill. We have added the names of volunteers to the exemption in the Public Records Act for anonymous anonymity for those who require it or request it. And we also tightened up the language that triggers the quid pro quo exemption to that. Instead of having it a nominal value, something of nominal value, it's now $500 or more. So it brings more certainty and provides much less ambiguity to the situation, and we strongly urge your aye vote.
Thank you very much. Other witnesses who'd like to weigh in support?
Madam Chair, Tony Triguero on behalf of California Teachers Association. We are processing an approved position. We supported the measure last year. We intend to support SB 330, and we request an aye vote. Thank you.
Thank you.
Thank you, Madam Chair. Members of the committee, Jeremy Smith here on behalf of the California Labor Federation, also in strong support.
Madam Chair, Willie Pillot, representing the American Federation of State, County, and Municipal Employees, asks for strong support from the members of the committee in support of the bill. Thank you.
Thank you very much.
Senator Court members, David Bala Hawkins with the California Faculty Association. You have before you a statement from the chair of our Political Action Legislative Committee. Unfortunately, an emergency arose. He was unable to attend. We're very appreciative of the support you gave on Senate Bill 218 last year. We believe the amendments address the governor's concerns. We ask for your aye vote. Thank you.
Thank you very much. Any other witnesses in support? Any questions for these witnesses, members? Witnesses in opposition? That's okay.
That's okay. I'm Kieran Zamaripa with the California State University, and we continue to oppose this measure. We appreciate the committee's judgment last year as it relates to SB 218. We appreciate the senator's belief that by taking care of volunteers, the veto is covered. I don't believe that's correct. I think there's still an underwriting concern here about shifting our auxiliaries that were created for specific purposes, not as state agencies, for a specific purpose, especially for the CSU, are now being defined that way. That is a fundamental shift in what these auxiliaries, how they operate, and what will they then be able to legally do. I appreciate the interest in accountability and transparency. I'd actually be fully supportive of a bill that did that and didn't fundamentally change the auxiliaries' functions. And with that, I think we are very concerned about its impact on our ability to bring in non-state revenues, to be able to manage federal and state grants and contracts for our faculty, to support applied research, And I would encourage all the members to get to know your campus auxiliaries a bit more, and we're going to take responsibility to do that so that you can understand and appreciate why their function, the way it sits today, is important to your university. Thank you.
Well, we certainly appreciate that. And I know that one of the main points of opposition last year was to allow for anonymity.
I know I never could say the word either.
For volunteers and others. Maybe you could just address that amendment, because that I heard what you said. It doesn't address all of your concerns,
Right.
but
Well,
I do believe it does at least address that issue.
It does cover that issue if a donor explicitly requests it.
Mm-hmm.
But I think that it's also clear that let's just talk about our prospect lists as it relates to potential donors that our advancement operations have identified through the normal research. We haven't even approached them yet, but they're on a list. They have not requested that their information be held anonymously because they haven't even been approached yet. One could argue that that list would be public information if requested under this bill. So while it's true that it protects somebody that says explicitly, I want that protection, it does not for those that we are working with that we haven't gotten a donation from, and would suggest that we need to go back through and ask each one of those prospects before we even ask them. Give them the warning that when they give, they better give anonymously, or they could be subject to the Public Records Act and release of that information. I would argue that could be true also for Alumni Association membership lists as it relates to those that we're working with also to seek donations from. So it is a step in the right direction. I want to be respectful of the attempt to do it, but I don't think it solves the whole problem, and it remains a concern for us.
Thank you very much.
Thank you.
Senator Yee, do you have a response to that?
I understand the opposition coming from UC and CSU. I think all of us would like to run this government and all of its related entity as quickly and as easily and unencumbered as possible. The reality is that we are working with public dollars. We are working with a public institution. And so what has been happening is that currently within the CSU and UC, they have to abide by, certain Open Records Act. What has happened is that over the last several years, more and more of these state functions are moved into these auxiliary organizations, maybe not intentional, but clearly the result is that these activities operate under secrecy, under this umbrella of, well, this is private money and we don't need to then tell you how exactly we're functioning. There have been court case or there have been scandals upon scandals within the CSU in Sonoma State, in Fresno, in other locations whereby public dollars have been now put at risk because of some of these kinds of secret deals that have been going on. And so what we're saying is that you can't do that anymore. You can't just simply, CSU, UC, move some of your functions into these auxiliary and somehow think that no longer will you be under the scrutiny of the public. Public dollars are public dollars. The fact that you are a 501c3, you then benefit from the tax laws of not only the state but also the federal level because you don't pay taxes. And so to that extent, you then benefit from the public good graces. And so what this bill will do is to essentially bring some sunshine to those particular activities. We did, in fact, heed, I think, the warning of the governor that he thought that this, the previous bill would chill any individual's interest and participation in donating. And so with this exemption, we hope that that will take care of it. With that, ask for an aye vote.
And Senator Yee, I just have one last question for you, very, very specifically on the issue of discovery of donor lists that might not fall within your amendment. Is that something you'd be willing to? It was just an issue that arose for me just now. But would you be willing to just take a look at that and see if that's something that can be included within the amendment that you did address?
Madam Chair, Jimmy with the Newspaper Publishers Association. The potential donor list, are tantamount to customer lists that businesses have and use quite extensively to market and the like, and has been considered a trade secret for decades. The Public Records Act recognizes trade secrets as exempt from disclosure under current law right now, and there's an extensive reference to it in the Public Records Act. There has been case law that has been developed with regard to what constitutes a trade secret, and it's very broadly defined. So for all intents and purposes, we believe that the information dealing with potential donors in the lists for both alumni and for foundations that they're concerned about would be protected under current law right now.
And would you be willing to work with the opposition to make sure that that's clarified?
Yeah, we've worked with opponents in the past on this exact issue, and we've included language to address their concerns. And as long as Senator Yee is
Are you okay with that?
Okay with it?
Very good.
I'd be more than happy
All right. Thank you very much for that. Any other questions, members? Motions in order?
With that clarification, I'm happy to move the bill.
Thank you very much. Do you have a close, Senator Yee?
Urgent aye vote.
Okay, thank you very much. We have a motion. And let's see, I don't think there were any author's amendments, so please call the roll on the motion.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Hancock?
Aye.
Hancock, aye. Leno? Walters?
Aye.
Walters, aye.
All right, that bill has 4-0. It will pass. It's on call, but it has votes to pass. Thank you very much. Senator Yee, I know you have another measure. Your next measure.
This is 438.
438, the item 3, charter schools and freedom of speech and the press.
This is a pretty straightforward bill. What this bill will do is to clarify any ambiguity or any misperception that in charter schools that there is the ability to censor or to exercise prior restraint. I don't think that the legislature, when we enacted the laws relative to charter school, suggests that if you happen to be a charter school student, that your First Amendment rights would have to then be checked at the doorway of that particular school. And so what this bill will do is to basically bring that provision of protecting students' First Amendment, making it applicable regardless of whether or not you are in a charter school or not. And this is an issue that came out of a report from the Orange County Register, and we have been talking to the charter school community and basically saying that we don't want to infringe on charter schools in terms of their ability to do whatever they want to do, but at least in terms of these First Amendments, kids' First Amendment rights should in fact be protected, and that's all it does.
And Senator Yee, there is an author's amendment or a suggested amendment that I believe you are agreeable to that does clarify what you have just said, that this is part of existing law and just clarifies the meaning that people do have their First Amendment rights.
That's absolutely right, and my apologies for that. We will accept that as author's amendment on that intent language.
We'll accept that. I know you have two main witnesses in opposition. Excuse me, in support. Pardon me. It's January. Please, go ahead.
Madam Chair, members of the committee, Jim Ewart, California Newspaper Publishers Association. We believed all along that charter schools were subject to this Ed Code provision, and it wasn't until the recent events that occurred at the Orange County High School of the Arts that we learned that there may be another perspective on this issue. And just to articulate it even more, the charter school's position was that the mega waiver that's in current law right now applies to them, and therefore the statutory protections that this legislature enacted in 1977 don't apply, and that charter school students who walk into those schools check their rights at the door when it comes to student expressive activities. We have seen the concern of the opposition with regard to the bill's, the perception that the bill attempts to invoke standards in their curriculum. And that's, of course, sort of the mission of charter schools is to sort of work outside those boundaries. We don't believe that that's the case. The only language in existing law right now that governs standards even essentially says shall be the responsibility of the advisor or advisors of pupil publications within each school to supervise the production of staff, to maintain professional standards of English and journalism, and to maintain the provisions of this section. We think that's a good thing and should apply to all schools, regardless of whether they're public, charter, or private, which are also governed by this statute, and we ask for your aye vote.
Thank you very much. Other witnesses in support?
Briefly, Madam Chairwoman, Francisco Labaco. On behalf of the American Civil Liberties Union, also in support, we were somewhat surprised also to hear that there was an argument on the other side of this. Clearly, kids at, to the extent the legislature should clarify, it should clarify that all kids, all public school kids, are entitled to the free speech protections of the statute. It's perfectly good sense bill. We urge your support.
Thank you very much. Other witnesses in support?
Mike Egan from the California Teachers Association. While CTA has not yet formally completed its process on this bill, we were enthusiastic supporters of SB 1370 in 2008 and anticipate being supportive of this bill as well. While we believe that there's a role for charter schools in the public education system in California, we also believe that the protections and guarantees of freedom of speech and freedom of the press should apply to charter schools, their students, and their teachers as well. Thank you.
Thank you. Other witnesses in support?
Madam Chairwoman and members of the committee, Willie Pelote, representing the American Federation of State, County, and Municipal Employees. We agree with the prior witnesses because we think it's a fundamental freedom to be able to express yourself, and we think that young people should have that while they're also in our education system, and that's for the members' strong support of the bill.
Thank you. Other witnesses in support?
Madam Chairman, Steve O'Donoghue, California Scholastic Journalism Initiative. I've taught and worked in scholastic journalism for over 40 years. There's the assertion that this is a curriculum issue. There's basically only one curriculum in journalism and only one standard. In California, we call it the professional standard, but you either know how to write a news story using facts and attribution, or you don't. Now, when that's taught, in what manner, is left completely up to the schools, and I don't see where this legislation would interfere with that particular control that charter schools currently have. Thank you.
Thank you very much. We thank you for your work with our students. Other witnesses, if you'd like to just address or state your support?
Madam Chair, members, I'm Paul Candell. I am the current California Journalism Advisor of the Year and the current National Journalism Advisor of the Year from Dow Jones Newspaper Fund. I'd just like to say that for 33 years, California has been a national model in terms of how it treats student press rights, and it would be a shame to put that reputation and that reality at risk by not passing this legislation. It should not be that students in California schools get two separate standards. They're both tax funded, and students in charter schools should just get what students in public schools get.
Thank you very much. Thank you for your work with our students as well. Thank you. Any other witnesses in support? Witnesses in opposition? Good afternoon.
All by myself. Rand Martin on behalf of the California Charter Schools Association. I want to make it abundantly clear at the outset that our opposition is not based on the merits of granting access to freedom of speech. We are agnostic on that issue as an association. Our concern, as has been stressed by several of the supporters, is relative to curriculum. And there have been assertions made that they're not quite sure that they see how this policy would impact the curriculum development in a charter school. We simply point to the same section that the CMPA representative pointed to, which is subdivision C, which talks about curriculum, talks about how the pupil, the student staff has to put a school publication together, how the advisor has to govern how that student staff is putting it together. We are, since 1992, when the legislature first adopted charter school language, we have protected curriculum development as the central tenet of charter schools. In 18, 19 years since that was enacted, the legislature has never imposed curriculum standards or any policies that drive curriculum standards through the legislative process. This would be a precedent-setting bill if it were to be enacted. I'd simply also like to point out that this is a mandate. Charter schools do not receive mandate funds. I realize at this point nobody receives mandate funds, but at least other traditional public schools are entitled to them. We're not. This would impose a mandate that would not be reimbursed to charter schools. And for those two primary reasons, we are opposed to the bill. Thank you.
Thank you very much for your testimony. Any other opposition? Members, questions from anyone? Moved by Senator Harmon as amended. Would you like to close, Senator Yee?
Just to say that when we were dealing with a lot of these First Amendment issues in our public school setting, the argument was exactly the same as what the charter school said. You cannot infringe on curriculum. I think we dispelled that particular misinformation. And again, I think you have heard from our proponents that this is not about curriculum. This is really just simply about individuals, free speech, and all of us deserve that, and including our kids who go to these charter schools.
Thank you very much, Senator Yee. There's a motion by Senator Harmon. Please call the roll on the motion.
The motion is due pass as amended to Senate Appropriations Committee. Corbett?
Aye.
Corbett, aye. Harmon? Aye. Harmon, aye. Hancock? Aye. Hancock, aye. Leno? Walters? Aye. Walters, aye.
That bill is out. The bill is on call with a 4-0 vote, so it has sufficient votes to pass. And the one remaining bill on the agenda today is item number 5, SB 650 by Senator Yee, dealing with the disclosure of improper governmental activities in the California Whistleblower Protection Act and in action for damages.
Thank you very much, Madam Chair. And this iteration is, again, in response to the governor's veto of a previous bill, 219. What this bill will do is to now bring both the CSU and the UC into this particular arena of providing protection for whistleblowers. I think the reality that we have right now is that the CSU and the UC are a judge and jury, and what this will do is to provide some relief for those individuals who are a victim of retaliation because they are a whistleblower. And with that, urge an aye vote.
Thank you very much, Senator Yee. And Senator Yee, I know that there has been discussion, and we should pass these out. Some suggested amendments to address a concern that was raised by the opposition. We do believe that the opposition's concern about current litigation is distinguishable, but to be absolutely certain that there isn't a conflict, we are asking for an amendment that I know has been discussed with your staff that would make that clear, that it is the intent of the legislature that this act not apply to, impact, or affect any claims that are pending as of the effective date of this act. And I do believe that that's agreeable to you.
We're fine with the amendment. We are fine with the amendment.
Thank you very much. And then there are some other amendments, just technical in the nature, reflected, just section changes, numbers, etc., that I believe you're also acceptable to.
That's fine.
And members, have you all had a chance to take a look at that? Okay, very good. Okay. Witnesses in support, please. 2 minutes each. 2 minutes each, please.
Senator Corbett, members, David Ball Hawkins, California Faculty Association. I'd like to refer to the CSU opposition letter because I believe that the claim is, with all due respect to the CSU, I believe that their claim is a very inaccurate portrayal of what this bill does. And it's the last paragraph on page 1. It says that this proposed change in law allowing an employee to file for a civil action at any time makes the internal investigation process useless and will no doubt lead to increased costs for the system. Frankly, we would agree with that statement if that was the case. But if you look at the bill itself, it's very clear that the administrative process needs to be exhausted before a civil claim can be filed. And that's on the top of page 5 of Senate Bill 650, where it says an action for damages shall be available to the injured party only if the injured party has first filed a complaint and the university has either reached a decision regarding the complaint or failed within the time limits established by the trustees. Current practice right now, if the trustees do not reach a decision within the 18-month allotment, then a civil action is permissible. We are simply clarifying in the bill that not only if there is inaction, but if a decision is finally reached, in other words, the administrative process has been exhausted, then a civil action also becomes an option in those cases. It is no intent of ours to circumvent the administrative process in this. We think that the CSU's opposition is based on that. We think that that is an inaccurate portrayal of what the bill does. We ask for your aye vote.
Thank you very much. Other witness in support?
I'm Mary Alice Coleman with the Law Office of Mary Alice Coleman, and I also am here to represent the California Employment Lawyers Association. We support this bill as we supported the prior bill. It's our position that UC employees and CSU employees essentially check their due process rights at the door when they become employees of these institutions, and they do not have the same protections as employees as other state employees. Senator Yee's bill will correct these inequities. They're badly needed. I have experience right now with one client who was terminated after 9 years as a researcher at UC after she reported some violations of human subjects research at San Quentin Prison. I think it's very important that this be addressed by the legislature, and we urge your support.
Thank you for your testimony. Other witnesses who'd like to state their opposition briefly?
Ali Cooper, Madam Chair.
Excuse me, support. I'm sorry. It's the first week of hearings. I'll get it straight at the next hearing.
Madam Chair, Ali Cooper, AFSCME Local 3299, University of California employees. We urge a strong aye vote. Our workers need the same sort of protections that other state employees enjoy with regard to this area of the law. We also need to be in a place where we're encouraging workers to report any sort of waste, fraud, abuse, or any other sort of wrongdoing, and we think this sort of legislation is a step in the right direction. It sends a right message to our public employees.
Thank you very much. Please state your opposition.
Madam Chairwoman, Willie Pelot.
No support.
The American Federation of State, County, and Municipal Employees. The bill is fair, it's equitable, and it mainstreams for these institutions what happens in our society in general, and we ask for your strong support from the members of the committee. Thank you.
Thank you for your testimony in support. Any other witnesses in support?
Yeah, Ruben Santos, Executive Board Member with AFSCME. We highly support this, and we're asking for you guys to look at this bill and give us the same rights as everybody else. Thank you.
Thank you very much. Is there another witness in support? Please come forward.
Jimmy, we're California Newspaper Publishers Association. This bill would protect sources of information that reporters use all the time, and we ask for an aye vote.
Thank you very much.
Yes, Maricruz Manzanares, AFSCME 3299 and UC worker, and I ask you to support this bill because it's very important for us to feel free of intimidation. And as a worker, sometimes we see stuff that can be dangerous to ourselves and also to our students or the community, and we can't do anything about it because there's no protection for us that guarantees us our safety.
Thank you very much. Any other witnesses? Witnesses in opposition, please come forward.
Karen Yelverton, Zamarip with the California State University. I am here in opposition to the bill, just to clarify for the chair.
Thank you very much.
I am regretfully here a second time to oppose Senator Yee's bill, but let me just take it on directly here. If what the bill did was what the proponents described, then you don't need the bill. Because right now, we have an administrative process where an employee who feels they've been retaliated against initiates an administrative review. The current statute then allows that process proceed, and the employee has a right to seek civil action if he or she does not get a satisfactory result after the fact. What this bill says is that if I have a complaint, I will file that simultaneously to the administrative review. At that point, I'm not clear what the value of the administrative review is. I think that the concern that is being raised is also before the courts in the Runyon case specific to the CSU that we think is appropriate to resolve what is satisfactorily resolved. If it's not satisfactorily resolved because the employee doesn't like the outcome, does that mean that it's not been resolved? And I think that investigations are meant to be investigations of the facts and a determination about what's the appropriate action to take. We don't disagree with the employee's rights to pursue action if they think they've not been treated appropriately. But what you're really setting up here is that both processes are going to be used parallel, or the administrative review process isn't going to resolve things that could be resolved before we have to go to court. We think that process has worked for us, and we're not really clear, short of dissatisfaction with always winning the argument, I guess, that the process is broken. So we strongly oppose this bill. We weren't included in the bill last year. I think it's because, frankly, I think until somebody found out how our process works, now wanting to tweak it further. But in fact, I think that it's working well for employees. It still gives them the legal remedy they're entitled to, and at the same time ignores the value added that you put in place in the whistleblower statute for us to have an administrative review to resolve some of these conflicts if possible. If not, then the employee, when that process is finished, has the right to go to court as they should.
Thank you very much for your testimony.
Happy Chastain, University of California. I apologize to the senator. We do not have a letter of opposition on file yet. It will be coming over this week. I am opposing the bill based on our position from SB 219 of last year. We did submit amendments to the senator last year, which were not accepted, and our letter will be reflecting something similar.
Thank you very much for your testimony. And Senator Yee, do you have any response?
This bill comes out of a court case in which judges felt that in the situation of UC employees where they do not have access to a judicial process, said to the plaintiff in that particular case that our hands are tied. Unless you somehow clarify with the legislature that, in fact, these UC employees who were whistleblowers, who were retaliated against, that unless you somehow clarify that it is intent of the legislature to give them access to the judiciary so that they can, in fact, get a fair hearing, then we can't do much about it. So this bill comes out of that particular situation. Why we expanded to the CSU was, in fact, to take care of a veto message that the governor put out that, we don't want to single out just simply UC. Other jurisdiction does not have that, and so that's how we brought the CSU in there. I think we've got to understand what it means to be a whistleblower. You work years and years in an institution. You hope to retire in that institution. You hope to somehow move along in its academic ranks or administrative ranks. Then all of a sudden you see something. And I will tell you that no one wants to be a whistleblower. No one wants to somehow end their career because somehow they spoke out. And so I would imagine that you're going to have a lot of workers who will try to work with the system to make those particular kinds of changes. There's some individuals who have a very low tolerance for some of the nonsense that may go on in our institution, and with all due respect to all of our institutions. There is a time and place where after a while, enough is enough, and you do, in fact, start saying to people that there's something wrong. And when you are retaliated against, you know that this is going to end your career. No one ends up being a whistleblower thinking that they're going to get a promotion. This is a career ender. And what this bill does is to provide some justice for these individuals. And that's all this will do. And to give them an opportunity after they have exhausted their administrative process that they at least feel that they have a chance to at least get something out of a rather horrendous process of an administrator or administrative process that are basically a judge and jury. So with that, urge an aye vote.
Thank you very much, Senator Yee. And I would just add, the analysis does quote the governor's veto message and, does state his support of correcting the current problem and ensuring that there is appropriate review for students, for the University of California and the California State University system, and in fact called for you to include that, I believe, in this measure. So just wanted to point that out too. Members, are there any additional comments or questions? All right. Is there a motion on this measure as amended? Thank you very much, Senator Leno. All right. We have a motion. Is there a close, Senator Yee?
Urge an aye vote.
Okay, thank you. Please call the roll.
The motion is due pass as amended to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon? Harmon, no. Hancock?
Aye.
Hancock, aye. Leno?
Aye.
Leno, aye. Walters?
No.
Walters, no.
Okay, thank you very much. That
Thank
bill
you
is
very
out
much.
on a 3-2 vote. And we can go ahead and lift the call on the other measures. Item number 1, SB 189, Lowenthal Mechanics Liens. Chair voting aye.
The motion was due pass as amended to Senate Appropriations. Leno? Leno, aye. Walters? Walters, aye.
That's a 5-0 vote.
Item number 2, SB 330 by Senator Yee. Chair voting aye and Vice Chair voting aye, I believe. That's a 4-0 vote currently.
Leno?
Aye.
Leno, aye.
You have to show me this so I can say. The next item is item number 3, SB 438 by Senator Yee, dealing with charter schools' freedom of speech. That measure is currently a 4 ayes, 0 noes. Please call the absent member.
The motion was due pass as amended to Senate Appropriations. Leno?
Aye.
Leno, aye.
All right. And that's out on a 5-0 vote. Item number 4, SB 580 by Senator Wright, dealing with child support and health insurance to address federal regulation. And that bill currently has a 4-0 vote. Please call the roll.
The motion was due pass as amended to Senate Appropriations. Leno?
Leno, aye.
Leno, aye.
And that bill is out on a 5-0 vote. And I believe that that concludes all of our business for the day.
Can you announce these two just to...
Very good. And I just want to make sure I announce 2 of the measures. SB 189 passed out on a 5-0 vote. That's Senator Lowenthal's mechanics lien measure. And then SB 330 by Senator Yee, dealing with public records and auxiliary organizations, passed on a 4 ayes. Excuse me. What's that? A 5-0 vote. All right. And that concludes our business for the day. Thank you all very much. We're adjourned.